I will wrap up quick and fast. The safari is waiting, and all of you are keen to go. And we all had a very heavy day too of conferences, and this is, I believe, the graveyard session. So very quickly, coming down to brass tacks. There was no presentation, I'll talk to you. We are a huge jurisdiction. We are 3.28 million square kilometers. We are touching 1.3 billion. We have 29 states, 8 union territories. But we have codified personal laws and we do not have a uniform civil code. Now I will deal very quickly with the two perspectives which involve children and the enforcement of orders vis-a-vis children who have to leave the country or who have to come back to the country. Let us first look at adoptions. Now, insofar as adoptions are concerned, we have the personal law, but we also have the Juvenile Justice, Care and Protection of Children Act, now 2015. We have a huge, large number of children who have to go into adoption. The Supreme Court in 3 successive decisions in Lakshmikant Pandey 1, 2 and 3 impressed upon the government to make a law, and ultimately a law came into place. We signed the United Nations Convention on Adoption Regulations. We created a central authority, and we have now an adoption law in place, which means a central authority of a foreign jurisdiction will maintain a register or will maintain a record of people wanting to adopt a child from India. There is a home study report, reports are exchanged, child is selected, a local court order is obtained, and upon the central authority, that is the Central Adoption Source Authority, giving an NOC in India, the child goes into adoption. We also have adoption regulations of 2022 by which there is a hastened process of inter-country adoptions, and persons, irrespective of marital status, are allowed to adopt. So we have, over a period of time, formed a very brisk, a very rapid and a very resourceful method vis-a-vis adoption of children is concerned, and internationally we have abided by the UNCRC, the adoption regulations. Now India has also signed the UNCRC. When India signed the UNCRC in 1992, India picked up all the important points of the UNCRC and incorporated them in the Juvenile Justice, Care and Protection of Children Act 2015. And India perhaps is the only jurisdiction which defines the best interest of the child, which is a definition which is not found anywhere. And that has universally been accepted in child abduction. Now, let us now travel to child removal. I don't want to use the word child abduction because even in the Hague Convention on Civil Aspects of Child Abduction 1980, abduction is a word used in the title of the convention. When you describe child removal, you talk of when is child removal illegal or wrongful, that is when the custody of the other parent is taken away or rights of the other parent are infringed. Now, in matters of child removal, we have not done well. We have the personal law of the parties, whereby the father and the mother are natural guardians, but it is also said that ordinarily the custody of a child less than 5 years of age shall be with the mother. Recently, courts have interpreted to mean that it is not necessary that the residence of the child should be the residence of the mother, but also the Supreme Court has said after him the mother is also not meant to be said that it's only after the demise of the father that the mother is the custodian. When there is a non-active father, the mother is the guardian. So that is one part of the story. But sadly, the Hindu Adoption and Maintenance Act and the Hindu Minority and Guardianship Act do not provide you a statutory remedy to go to court. So where is the fallback? The fallback is on a 133-year-old law called the Guardian and Wards Act of 1890. Now this is a colonial, outmoded British piece of legislation which talks of how and why and under what circumstances anybody can be declared the custodian and the legal guardian of the child. So invariably, when there is a offending parent removing a child from one jurisdiction to the other, the parent seeks sole custody and sole guardianship. Now this, in my humble view, in today's times, is highly outmoded, is highly detrimental to the best interests of the child, and it goes against the concept of shared parenting and joint custody. Now, on the one hand, we have done so well in adoptions that we mark the best interests of the child. But when it comes to removals, we talk of singular custody. Because the family courts are guided and controlled by the legislation, that is the Guardian and Wards Act, so shared parenting, joint custody are concepts which are only created by courts. So it is only the paraphraseology of the court in interpreting past such other orders that this coinage can come in, but through a backdoor interpretation or by the wisdom of a court. So what happens? Parental alienation syndrome. So if the parent who has removed the child wants to take the child back, the courts are now telling the other parent, please go back with the children. If you do not wish to go, then you stay back. I have, over a period of 3 years, in one particular matter, been able to successfully get the family to go back. After the Delhi High Court gave protections to the mother of getting not being implicated, not being charged with a criminal offence, being afforded protection, being the primary custodian of the mother, I got all these conditions and I got them mirrored in the court in Connecticut, and the Supreme Court upheld it. I think it was a very fair formula. The mother got the protections. She was not prone to domestic violence or any other issues, and therefore this passage became a good way. But the problem is that this doesn't happen in every case. So what is happening? Parents are removing children illegally. They are crossing borders illegally. They are breaking the law. I don't endorse it. But then law is a crutch to aid justice. The crutch is slow. So what is the thought process? I was an amicus for 12 long years in a matter where a child was removed to UK by an aunt. We could not bring the child back to India. So I, on the debating of office of the Honorable Judge, submitted a report. It was sent to the Government of India. The Government of India sent it to the Law Commission, and ultimately a committee was formed, the Hague Committee, in which I was a lawyer member and there were judges and government officers. So we came out with a 2-volume report and we've given a bill. In the bill, we talk of wrongful removal or retention of a child being defined. We also stipulate when should a child not be returned. There are plenty of stipulations. We have suggested to the government that the matter go before an authority who will determine whether we should return the child or keep the child or let the mother go back with the child. So before we think of signing the convention, we can possibly look of making a legislation. We have to ultimately enforce the convention. We are not obliged to copy the convention in total. So we can piecemeal and cherry pick the convention. But in my humble view, if I were to compare the adoptions convention and the abduction convention, I would give a hands up to India signing the Hague Convention. And I would look for support. How many of you do you think India should sign the Hague Convention on child abduction? And how many of you think no? My learned friend is outnumbered. Anyway, so I think this is a thought process. We cannot live in a no man's island. We have to become a part of a system. No foreign court allows a child to come to India anymore. Because the fear of the court is the child will never come back. I have started doing MOUs now to bring children back on visitations. I've recently done, just 1 minute, a matter which was a very unique case. Polish mother, American father, of Indian origin, divorced, mother in Poland with the daughter, father living in America. They agreed to share the custody of the child. The mother refused to part with the custody. The man got a warrant issued in the US. She was forced to bring the child to the US. He wants to bring the child to India on holiday. Mother says, I'm not allowing the child to go to India because he will never come back. The daughter will not come back. So, I drew up an MOU on the conditions on which the child will go, and the passport of the child was deposited with an associate of mine. And there was a complete monitoring of the whole case. So this is the kind of situation we are on to. Now Alexander is looking desperately at me and saying, it's time, we are going to switch the lights off. So Alexander, thank you very much, and thank you for giving us the opportunity.
And Rajat, I want to thank you for just being such wonderful sports this conference. You've made us all laugh, you've participated so brilliantly. I'm so glad you're here with your lovely signing kit.
I want to go on the safari.
I'm going to let you all go. I just want to say thank you so much for coming, everyone.